Honourable David Parker.
Thank you, Mr Chairman. Can I thank Materia Ture for those supplementary order papers, and I'm sure that the Labor Party would support something like that to bring forward the review. We still think it's preferable to have a two-track process starting today, which would have put a parallel bill to Select Committee for consideration of submissions that could be called tomorrow by the Select Committee and heard in the normal process. And within a year we would have a fully worked through parallel bill that fixed all the mistakes that there are no doubt in this bill, and there is no doubt that there are mistakes in this bill, and that would take effect on the expiration of this bill, which could then have a termination date of a year from today. That would be a better solution, but the government's rejected that. I think that shows how abusive they are of parliamentary processes generally, how unconcerned they are to get the exact balance right between civil liberties, but also how unconcerned they are to protect the members of the public properly in the interim period between now and when that review that they've got currently set out there 2 years ahead. On that last point, I want to return to an issue that I raised with the Minister last night, which is that there is nowhere, as far as I'm aware, in New Zealand law a requirement on people who've got convictions overseas to disclose those to the New Zealand authorities. Government members aren't saying I'm wrong. We've had no advice from the contrary to the Minister, and that seems to be nonsensical. Someone can return to New Zealand with a serious criminal offence overseas, and they've got no New Zealand authorities have got the right to get that information from them. They might get that information from Interpol sometimes. They might get it from a cooperating country like Australia sometimes. There are other countries in the world that are in no state because of their civil disorder to provide us with that information even if they wanted to. So there are no doubt instances in New Zealand where returning serious criminals do not have a duty to provide information on what those convictions were overseas. So let's take what happens under this bill, Mr Speaker. This bill only applies in respect of orders for returning prisoners if people have been returned within 6 months from their release from custody. So we can't find any protection in that subpart 2 of part 2 of the bill. And in respect of part 1, the only thing that they're required to provide us is identifying particulars. And as I've said in earlier contributions, those identifying particulars as defined in the Police Act are biographical information. They go to identification of the person, not their convictions. So there is no doubt in my mind that classification of identifying particulars in this legislation does not extend to their prior convictions. I want to also point out another problem with this bill, which I think is unintentional, and again points why we should be having this two-track process. Clause 9 of the bill says that the police may, as soon as reasonably practical, request a returning offender to provide identifying particulars and may detain the offender under Section 10 if the offender refuses. Clause 10 then says that the right of detention only applies for 6 months after the offender's return. Okay? So again, it's clear that this requirement to get to effectively have a compulsion mechanism so that you can get those identifying particulars, that only applies for the first 6 months after someone's return. What is the policy rationale for that? I don't understand why it is that you wouldn't want to have particulars of people who, because of maybe Australian incompetence or New Zealand authorities' incompetence, it doesn't happen for the first 6 months. All of a sudden there's no need to have particulars of people who weren't picked up but had serious offences but weren't picked up until in the first 6 months. And indeed this actually shows a problem in respect of this legislation of what's already happened. Now, I agree that you shouldn't have retrospective legislation that impacts and places people at double jeopardy retrospectively, but it's actually a different thing to say that prospectively information that you should have collected previously but you haven't collected because of the incompetence of the government, that you shouldn't actually have the right to collect that information in the future if it's necessary to protect New Zealanders. So I think that it is proper that the New Zealand authorities get information on people who've had serious convictions overseas after they return to New Zealand, even if you don't ask it for the first 6 months. Ask for it for the first 6 months. After this legislation passes, we can do something in respect of the first 6 months, but not thereafter. Another issue which actually cuts the other way. We actually might be going too far in respect of some offences. I was thinking about how this Mr. Chairman.
The Honourable David Parker.
I was thinking about situations that go the other way. If you're a person who's under 27 years old and you're a New Zealander, you've got rights to live in the United Kingdom for up to 2 years and get a work permit. I think that's, in general, the rule. It might have been tightened a little, but it's something like that. And I know this to be a thing because a particular relevant issue, because it actually happened to a friend of mine. A friend of mine stayed over there for longer than the 2 years and was then at risk of prosecution. Now she actually departed the UK, but others don't, and actually overstay in breach of immigration laws in the UK. And if they're convicted, they're actually liable to an imprisonable, it's an imprisonable offence, and it would be in New Zealand too, an imprisonable offence, the maximum sentence for which would be more than a year imprisonment, I think. You would also be liable for deportation, even if you're not deported. You'd be told that you're liable for deportation, and you'd find yourself coming back to New Zealand. You would actually be a returning offender within the definition of 7A. Now, we might want that, but I haven't heard any government member or the minister actually say that that sort of returning offender is going to be caught by this legislation. I think in theory they are. And yet the person that I've talked about earlier, the person who might have a murder conviction or a paedophilia conviction in an overseas jurisdiction some period earlier, comes back to New Zealand, and we've got no right to get the particulars of their prior offending, even if they might pose a threat to the New Zealand public. That's another illustration of how this legislation might not be getting the balance right. It might be attaching to people to whom we might not, as a parliament, think it should attach. It might not be attaching to people who it should in order for protection of the public. It's another reason why I cannot see why the government is being so stubborn about refusing to allow the parallel process where a second version of this bill goes to select committee so that we can actually consider these issues. Members of Parliament have done their best on this side of the House to make these contributions upon a simple reading of the bill, thinking what the implications might be. People who are more expert in areas of the law than we are, specialists or people from the Law Society with a special interest or victim impact groups, they will have other issues with this bill that we have not thought of. And we are not going to get the opportunity to improve this legislative regime as a consequence until we have a review. Now, I suspect the Minister is going to come and say, well, look, maybe the review period should be brought forward a little bit so it doesn't coincide with an election, and that's a good thing, and I thank the Minister for that, and we in the Labour Party would support that if the Minister is going to do that. Finally, and I see I'll just recap on one point, given that for the ability of the Minister. I don't accept the circular definition point. One of the points the Minister made yesterday was there would be some circularity introduced because if you had the requirement to provide particulars but you didn't know that they were a returning offender, then you wouldn't necessarily know to ask them, and therefore it's circular. It's actually not circular, it's just that it wouldn't always apply. And given that clause 9, in terms of the request for identifying particulars, always applies, it doesn't expire after 6 months. The only thing that expires is the government's right to detain for non-compliance with the request to give identifying particulars. I think we are left with a gap in the law where it is a nonsense that someone who has returned from overseas, let's say someone's picked up on a suspected paedophilia charge outside of school. This can happen, does happen in New Zealand, and they say, oh, we don't know about you, what have you been? Oh, look, I've just come back from overseas, I've been overseas for 10 years. That person has got no duty to tell them whether in that 10-year period they were spending 10 years in prison in Pakistan or something for charges relating to children. That's got to be a nonsense, and we can fix it in this legislation by requiring that people who return from overseas who are a New Zealander who has been convicted in overseas jurisdiction of an offence that constitutes an imprisonable offence in New Zealand and was liable for deportation, you don't have to be deported, you just have to be liable for deportation, that person has a duty to provide information to the police if requested as to what their conviction was overseas and what their penalty was. It seems to me a very sensible proposition from the Labour Party, and so I would hope that Parliament backs my supplementary order paper.
The Honourable ABN.